Welcome and good afternoon, everyone. As Media and Law Studies Association and the International Press Institute, we're holding this online panel to discuss the findings of our Free Expression Trial Monitoring Report, which covers February 2019 to March 2020. And I'm Koçak, MLSA Project Coordinator, and I'm here with Scott Griffen, International Press Institute Deputy Director, and Elif, freelance journalist, and also she monitors hearings for MLSA as part of this project. And in fact, MLSA and IPI began their trial monitoring efforts in 2018, in June 2018, and we published our first report in January 2019. It was a 6-month report where we published the first set of findings. And then we moved on to this other project period where we monitored hearings for 12 months. And we published bi-monthly reports throughout this process. And then now we're sharing the final report findings. And during this period, our monitors attended 319 hearings covering 169 cases between February 26th, 2019 and March 6th, 2020. And the hearings were all picked based on the European Human Rights Convention's Article 10 on freedom of expression. The majority of the defendants were journalists, although we also monitored hearings of academics, writers, lawyers, and students. And we had 19 court monitors who monitored hearings in 15 cities across Turkey. And the majority was, of course, Ankara, Istanbul, and Diyarbakir. But we also focused predominantly on Kurdish cities as well. So now I would like to give the floor to Scott Griffen to briefly discuss the key results of the trial monitoring efforts.
Thanks, Ece, and good afternoon to everybody. Maybe just to add, why did we start doing this project and doing this trial monitoring? It was because we knew that there were a lot of problems in Turkish courts in trials, especially where journalists were on trial, where journalists' basic rights in court were not being respected. Journalists being held in pretrial detention without grounds, severe violations of the right to a fair trial, the right to counsel. So we knew that all of these, we knew anecdotally at least that a lot of this was happening, and we wanted to delve deeper into this and come out with some facts and figures and to really see what is the scope of the problem that we have been observing in Turkey throughout the crackdown that began with the failed coup. So I'm just, and as Ece already said, this started actually back in 2018, and between 2019 and 2020, we monitored over 300 hearings, most of them journalists, but also other cases of individuals who were on trial related to their profession. So I'm just going to go through a couple of bullet points of what we found through this trial monitoring. And the first thing is that, which is actually wasn't a big surprise, but it confirms what we feared, was that the majority of defendants that were on trial in these freedom of expression cases were charged with terrorism-related crimes. And that was actually 60% of the cases monitored. So 98 out of 169 cases were terrorism-related cases, which just underscores once again how that Turkey's anti-terror laws are the main and most convenient tool for the government to charge journalists and others using freedom of expression to accuse journalists who are writing critically about the government or other topics of terrorist-related crimes. And this is again shown in the number of convictions. So we had during this period 89 journalists were convicted in these trials, and 78% of these convictions were again for terrorist-related crimes, which tend to be again heavy sentences. And obviously, these terrorist-related cases are also an easy way to smear and to really also change the public perception of what journalists are doing by calling them terrorists. Is something that we hear over and over again, and we think this added to this harassment of journalists. And what was really concerning, what we found is that prosecutors are also using journalistic work, legitimate journalistic work, which can also be criticism, even criticism that is expressed harshly, as evidence of terrorism. So we found that in 76% of terrorism-related cases, so freedom of expression cases where the defendant was charged with terror crimes, the prosecution relied primarily on journalistic work as evidence. And this is obviously a huge problem, that legitimate journalistic work is not only being smeared as terrorism by public officials in pro-government media, but it's actually being used in court as evidence, and it's being used as evidence that is then used to support convictions. And this is for us obviously one of the biggest problems that we have found, and something that has continued, unfortunately, throughout this project. And just to give you an idea, the most common types of charges we're talking here are usually conducting propaganda for a terrorist organization or alleged membership in a terrorist organization, in some cases also committing a crime on behalf of a terror organization. As I said, in most of these cases, journalistic work, in some cases also social media posts, were being used to support these crimes. So there's a huge blurring of the lines between journalistic work and freedom of expression and terrorism, and this dividing line, and there are a lot of international standards around this line, has been completely blurred in Turkish courts, and our report really shows that very clearly, unfortunately. Then we looked at a number of other factors throughout this monitoring period. One of these was the number of defendants being held in pretrial detention, which at one point was scores, well over 100 journalists being held in pretrial detention at different points following the coup attempt. That number fell over time, and at the time we published this report, this final report, it was a fairly small number. But I think it has to be said, this is a very severe violation of journalists' rights. In many cases, suspects were held without proper indictments, without proper charges, for extended periods of time, well beyond what should have been permitted. And I think it also has to be said that although we see a decrease in pretrial detention, this actually doesn't reverse the wrongs that were done to those journalists, which was a severe abuse of their rights. They haven't been compensated for those rights, and I think in some cases, that the psychological damage that was done in those extended pretrial detention periods is something that obviously hasn't been made right. So I think even this finding that pretrial detention has declined, we have to be very careful to see it really as a mixed result. We also looked at courtroom conditions, which have to do with things like space in the courtroom and the treatment of defendants by judges. We saw in many cases throughout this project that judges, for example, appear to violate the presumption of innocence in the way that they treated defendants, in the way they spoke to them, in the way the defendants were brought into court, for example, often handcuffed in violation of the law. Here we also saw to some extent an improvement in these metrics. So these actually dropped. At one point we had adverse courtroom conditions in 50% of hearings, and this actually dropped to 20% at the end of the trial monitoring program. So somewhat of a positive move there. Another point relates to the right of defendants to appear in court on their own behalf. When we began this project back in 2018 and 2019, there was a big problem with the use of segbus, which is a video conferencing system. And in particular, in the eastern part of Turkey, we had a number of cases where journalists, especially Kurdish journalists, were held very, very far away from the place where the trial was taking place. It was an isolating mechanism, and in many cases, they were actually denied the right to personally attend their own trial. And to question witnesses and to fully participate in the trial. And this is, for us, a severe violation of the right to a fair trial, not to be physically present In some cases, we also had problems with the technical aspects of segbus, that even when they were hooked up to this video link, there were technical issues, it didn't work, translation didn't work in some cases if they were trying to participate in Kurdish, for example. So there was, at one point we had a huge wave of these types of problems. This also decreased over the course of the monitoring project. But I think, again, here it has to be said that these segbus issues also came up in a number of trials in which journalists have already been convicted. So I think while we can say that in some cases there's a positive trend in terms of the numbers, we need to look back and say, what was the impact of these severe violations on convictions that have already occurred? And not to simply say, well, the numbers look better. We have a continuing problem with the right to a lawful judge, which is the principle by which every defendant should have a right to appear before the judge who is set forth by law. And unfortunately, in many of the cases that we observed, members of the judicial panel were changed out during the trial. In some cases, for example, in the Osman Kavala case, for expressing an opinion about the case. And this is also not only a material violation of the rights of defendants, but also really negatively impacts the perception of fairness. Because it appears that judges are being changed out on the basis of how they might rule, or judges put in some cases with the expectation that they rule a certain way. And here, this has been actually a challenge throughout the entire monitoring period. And in 27% of cases, actually, we saw that at least one member of the judicial panel was changed out. And in 22% of cases, it was the presiding judge who was changed out. So when you have this type of regular changes in the makeup of the judges, this is something, again, that severely impacts defendants' right to a fair trial. It violates a number of international principles. So this is a concern, and we don't, I think, see a systematic improvement here. And I just want to say also, we in our final report, we sort of had a mixed conclusion about what can we say about the full period that we have monitored. And as I said, there was to some extent an improvement on certain metrics. So we saw a little bit of an improvement in the way that, in the professionalism of the trial, in the way that judges treated defendants. We saw an improvement in the use of segbus, a decline in the use of segbus. But overall, I think it has to be said, and this is our key conclusion in the report, that the judiciary remains heavily compromised in Turkey, and we can see this in two ways. One is that the vertical power structure of the judiciary in Turkey hasn't changed. So the influence of the executive branch over the High Council of Judges and Prosecutors remains. And as long as you have a system which allows the executive branch and the president to influence the makeup of the judicial branch, it's not possible to speak of, I think, really a true shift toward independence, because you always have this sort of factor lurking over the entire judicial branch. And the other thing I think that has to be said is that we still see a number of cases coming before courts where this arbitrariness, which has been in place, again, in the past few years through the crackdown, still remains. And I think actually just this month we had a decision in the case of Deniz Yücel, who is a German-Turkish journalist, and his case is an example of everything that can go wrong, all the ways in which journalists' rights can be violated. He was held in pretrial detention for almost a year, much of it in solitary confinement. There was no indictment in his case until after a year of being behind bars. He was eventually released and allowed to return back to Germany. His trial continued in absentia, and actually the Constitutional Court ruled that his rights had been violated. And despite the ruling of the Constitutional Court, this case went forward, and he was eventually convicted this month and sentenced to nearly 3 years in prison in absentia. But I think even this case is a microcosm of all of these types of violations that we have picked up, and it shows that the lack of independence and this arbitrariness is still very much a factor. So I think overall our finding is that while there have been some improvements on certain metrics, there is still the judiciary is still compromised to a very significant degree in Turkey regarding journalist trials. So I'll leave it for there, and then I'm sure we can come back to some of these points later. Thanks.
Thank you so much, Scott, for this comprehensive summary of the report. Actually, to add on to your points, I would maybe like to point out that we observed these slight improvements in, for example, the professionalism regarding conduct of judges, also the decreasing number of the pretrial detention, use of pretrial detention and segbus. But these numbers are affected so much by the specific time period that we chose to cover. As Elif will probably also explain, the year that this report covers didn't see that many big profile cases where there are multi-defendants who are in detention. By the time that this report's period began, we have already seen the ending of such big profile cases, and many journalists who have been tried in detention have already been released. But again, this doesn't mean that the prosecutions that we monitored were fair. Still, even if a journalist is not tried in pretrial detention, the accusations that we see, the evidence that we see is completely baseless in many of these cases that we monitored. And also, maybe one thing that was important this year with this report was that we tried to monitor as many cases as we can without really looking at whether it's a big profile case, whether the journalist is a famous journalist or not. And this actually also improved solidarity, I think, among journalists, because this project, because of its extent, I think also provides some sort of solidarity for journalists who are on trial, because sometimes we go to hearings and we monitor them, and MLSA monitors are the only ones who are there. Despite the lawyers, and maybe the lawyer is not there even. So I think despite this being a very, very important analysis and a very important scientific work even, it has even greater value in terms of the archival value that it has and the solidarity value that it has. And one important thing that I think we did in this report was that we included case studies in different categories of trials based on charges. And you explained the terror charges really thoroughly, but one thing that is heavily highlighted in our report is that although the judiciary is indeed quick to link journalism with terrorism, it's the Kurdish media, definitely, or pro-Kurdish media, faces much bigger pressure by the judiciary, because, for example, one article that is used very arbitrarily when persecuting journalists is that is the law about aiding and abetting a terrorist organization without being a member. And this law is used so arbitrarily that even editorial policies or the tone of a newspaper's news reports can be used as evidence for aiding a terrorist organization, and with heavy prison sentences, despite there being any organic connection to a terrorist organization, or despite being any solid or reasonable doubt. But we see that, for example, in Kurdish media, Kurdish journalists this is explained in the case studies that we highlighted in the report as well, they are without exception charged for membership in a terrorist organization, claiming that these journalists who work for Kurdish media outlets indeed work for a terrorist organization. Their presumption of innocence is violated almost immediately. But besides the terror charges, the most important charges that we highlighted in this report were insulting the president, denigrating the Turkish nation, revealing state secrets. This is a broad, actually, term. Many different articles can be used against journalists when they're accused of revealing state secrets, including the law on the National Intelligence Agency, because it's now been started to use as against journalists as well. But yes, especially insulting the president and denigrating the Turkish nation charges are also used or abused even by violating international legal standards as well. And also disclosing the identity of officers on anti-terror duty has been used for persecuting journalists very, very frequently in the last year. Even writing the name of a prosecutor leads to a 10-month, 15-month suspended prison sentence. And this, even the fact that whether the prosecutor is a public officer who works in anti-terror duty is questionable. But let me give the floor to Elif now to talk about her insights on maybe why the improvements that we saw in this period were caused by, and also her own experiences in the courtroom as a monitor. You're muted.
Firstly, I'm sorry, excuse me, because I have really bad internet service today. It has been like this since the morning. Well, I should say that we have been, before the MLSA even funded, when we were talking about this project, we have been already covering the trials, especially the freedom of speech trials, for the past 8 years, or 5 or 8 years, I believe. So we decided to do that. And I should say that the MLSA is the very first group that actually observes the trials systematically and in a plan in Turkey. So thinking retrospectively till today, we can say that the main reason that we see this positivity in the numbers, that the improvement, as you mentioned before, is the big profile cases has been already ended. For example, we first started, there was very intense FETÖ trials after the coup attempt. There are a lot of journalists who has been imprisoned, and their trial prosecution was continued. And also the Kurdish journalists, it's same for the Kurdish journalists. And Italy how can I say, continued for a long time. But now when we came here today, for the past 3 years maybe, we have a big profile trial, for one big profile trial every year, for example. For example, last year it was Gezi residence trial. This year it's the MIT members' funeral report trial. It's a very hard to pick this, so it's very, how can I say, very full package. So it's easy. That's why it's easy to say that because of this prosecution process has ended, the positivity increased, because we don't have this kind of very highlighted trials. And we should say that because of the political judiciary system as we have, unfortunately, the big profile means that big segment through the commitment to the government. Therefore, the panel courts actually, and also prosecutors' position is much more agitated than the very low profile trials. For example, some of the Kurdish trials, some of them, I can say. When it comes to today, I should say that our presence, besides the lack of the big profile trials, I should say that our presence means something in the courtroom as well. We actually see the change because of it, because we seen that the panel, the judges addressing to the press during the trial, for example. We see that they were asking, who are we, what are we going to do there, where are we observing for, where are we working for example. It didn't happen before. They never actually really cared to ask. And maybe more recently, I should say, for example, 2 weeks ago, there was Mehmet Yakup Yılmaz trial, and it was the prosecution was continued in the criminal court of first instance, which means that there's no prosecutor and there's no penal court. It's only the judicial court. There's only one judge, and usually in those courts, when they reach a verdict, there's only one judge, so there's no negotiation between the judges, they usually tell. And it was very obvious verdict because the complainant was the Binali Yıldırım, and he already withdrew his complaint. So we were expecting an acquittal, and the judge asked us to leave the courtroom, then wait for a while, like 5 minutes. Then we got back, and she said that it's going to be acquittal. So I asked this to the lawyer, and I said that why is she doing it like this? Because it's the criminal court of first instance. And he said, because you are here. I mean, that's actually very visible in that terms, that our presence affecting the continuation of trial. Also, it's affected the, how can I say, all the courtrooms atmosphere regarding the entering the room, the, how can I say, katip, the writer, the recorder,
The clerk too.
the clerk's approach to the press and the observers, and the panel court's approach to the press and observers. It was very easily to say that it really happens how the judges and the prosecutor is referring and addressing to the defendants as well. For example, with respectively, for example, in Turkey we have in Turkish we have sen and siz, two different pronouns, which is for respectively. The other one is for very informally, and especially in Kurdish trials, we usually really how can I say, largely observe that the judges referring Kurdish journalists or all the defendants very informally, while they were judging very respectively to the non-Kurdish defendants, for example. Now it's really less because we always mentioned that in our forms as well. Regarding the forms, maybe I should say that our forms are very detailed regarding the inside the courtroom and the courthouse. Maybe we actually write down every detail. We have some difficulties in how can I say, technical issues in the form, but mostly it's very easy for you to just seize the atmosphere of the trial. Also, we will plan to, if I'm wrong, just correct me, Ece, we will plan to make much more detailed reports this year, because the violation of the fair trial doesn't start and ends in the courtroom itself. I mean, when we're talking about the segbus and how the segbus system is used for as a violation of the free trial, is because it's actually also sometimes it's a chance to use for, I mean, it's preferable for the defendants as well, for example, because when they are bringing the defendants, if they are imprisoned journalists, for example, if they bring them to the court, it's a very, how can I say, it's a very bad process for them, because they wake up like 5 in the morning. They just make them wait 3 hours on a chair. They just handcuff them, put them in a prison car, which is very close, and they just rode it very long distance. Like, for example, when we're talking about Istanbul, Silivri and Çağlayan's distance is 3 hours if it's a busy, it's a traffic jam. So they just sit in a very close car with handcuffs for 3 hours, then came here and wait in the underground till the trial starts. Therefore, they prefer not to come, so they use the segbus, for example. It's actually make them to not to use their right to be present in the courtroom. So maybe we should really be able to actually add this to our reports, or in a very general term, because it will affect the trial's prosecution. Because, for example, while the Selahattin Demirtaş wants to attend the court, the Ahmet Altan really doesn't want to attend the court, and he was saying that I don't want to get in this process at all. And the other one is the influence of the political system, the government or the municipalities or the mayors during this process. It's very obvious when we are talking about the Mitrax trial, It's very obvious when we're talking about Tunal's trial, a translator, the academic who was prosecuted because he was a translator in the conference, for example, because they were all how can I say, targeted by high-profile governmental bodies, sometimes politicians, sometimes mayors, etc. And it affected. I mean, we could able to see the same charges on the indictments as well before the indictments were even formed. For example, in Tunal, the mayor has made a press release saying that we captured a terrorist organization's member and held in blah blah blah. And we see that the first time when he was arrested and detained, actually taken to the prison, the first charge was because of that. It was a member of a terrorist organization. And when we wait for the indictment, we said that they just dropped the terrorist member of terrorist organization's member charge and convert it to aiding a terrorist organization, which is also another part, another problem during all the judicial system in Turkey, the call of the aid to the terrorist organization. So when I believe that if we realize our plan to read this detailed report this year, it will be much more helpful to see the actual environment of this process. So yeah, it's like now it's for me 10 years in courthouse to observe these trials and covering these trials. It's a shame in most of the way. Yeah. But we can say that all the judiciary members, from the securities to the judges, they became much more aware of our presence in the courtroom, in the courthouse even, and it makes them to at least follow some of the rules. But of course, it doesn't abide to judges like, always I give the same name, but Akgül, a very militant, very political judge, who actually very known for not letting the defendant to make his or her defense. So when we know that, actually Scott, I believe, mentioned before, the change of the panel court, the court members' effect on the trial, we can see, we can actually foresee what's going to be the verdict when we see the trial, the judges itself, or the prosecutor itself. When we can see the end of the trial, before the trial, I mean the verdict, when they apply the specific prosecutor to the prosecution. Therefore, it's very political, and it's sometimes we cannot do anything about that.
Exactly like you said, and with the example you gave, Akgül, for example, is someone that Scott also mentioned, is definitely seen as someone who is appointed to certain courts to rule in a certain way in critical cases, and this happens a lot. And the report also highlights some specific cases where panels change frequently in very, very late stages in cases, in order for a specific panel to come just to give a verdict in a very controversial case. But Elif, you're right. One thing that is also included in the part that we discussed, the findings of our strategy meeting, which we conducted with lawyers and other civil society organizations that monitor trials in Turkey, is that, and we try to do this even in this report a little bit, but go beyond the courtroom and go beyond the hearings when analyzing such cases, because as you said, like the violations of the right to a fair trial or the violations of the presumption of innocence begin before the first hearing, when someone is detained, when someone is initially arrested, when the indictment is being written, even there are countless violations that intertwine to each other. And also, as you said, either government officials or news reports that defame these journalists who are on trial or who are in pretrial detention influence both the public's opinion and also the court's opinion, even before the hearings begin. So it's important to look at this process as in a more holistic way, I guess, and not, I mean, because it's definitely, like you said, this definitely doesn't happen in the just in the courtrooms, and sometimes the hearings are just done for formality, even, and it's important to see through that. And one thing I wanted to add was the actually, like, there are some case, like the case studies that we mentioned in this report. We also try to highlight some trends that happen. For example, when I mentioned the denigrating the Turkish nation charge, this, like, we see with each operation, for example, each military operation launched against Syria, there was a new wave of detentions all across Turkey, and not just journalists, but also citizens who use social media. Any kind of critical social media posts, tweets, are reason for persecution, are reason for even detention. And we see, as part of these operations, very, very large, what we call in Turkish, bag trials, where there are multi-defendants in which journalists are added. And whether this is insulting the president, inciting the public to hatred and hostility, terror propaganda, it varies. But usually journalists sometimes get mixed up in these trials, which even makes us methodologically harder for us to monitor these trials. For example, if there's 30 defendants in a case and only 4 are journalists, it really, even with the form that we use to monitor these hearings, which I will also talk about a little bit, it makes it hard. But also, one thing that we highlighted, for example, in the case studies, which I find important, is the pressure on financial and investigative journalism, because it has a rather unique quality in Turkey at this time, because, I mean, mostly, despite insult and libel charges, these finance journalists don't really face terror charges or sometimes even criminal charges, but they face huge financial reparations filed by big companies in Turkey. So this happened with Paradise Papers reporting done by mostly Pelin Ünker, but also Çiğdem Toker, famous investigative journalist who predominantly reports on tender bids, very, very large profile public tender bids, and basically unravels how large pro-government companies are favored in these tender bids. And it's come to a stage that these companies find it very, very easy to sue these journalists, asking record-breaking reparations, which even if it's not like something as serious as a prison sentence, this causes incredible financial pressure on media outlets. And even if it's just basically an inconvenience at this point. But also one other example that, and Elif, you were the one who monitored this, was what we call the Bloomberg trial, where 2 Bloomberg finance reporters based in Turkey were charged, along with other actually journalists, as a total of 38 people, including citizens, copywriters, students, basically and they were charged with defying the capital markets law for influencing the currency rate by tweeting on the financial crisis in Turkey. And in terms of the report, you mentioned it a little bit. I wish we had the chance to show it actually during this broadcast, but it's a very, very detailed report which we based on a court monitoring report done by OSCE. MLSA legal team sort of adapted it so that it could be used for the Turkish judiciary. And it's actually a live and ever-changing form, because we, even during this 12-month process, we changed it when we seemed fit. We added some questions because, I mean, the trends change all the time, and the needs for the report change also. So, like, we're always in conversation with our monitors to make the report easier to produce. So, Scott,
can I just add something,
yeah,
just
sure.
to comment on what we've been talking about? Because I think one of the things that the report really shows very clearly, but also speaking more broadly about the situation in Turkey now, is just this sense of arbitrariness that hangs over so many of these trials. And you mentioned the fact that, we also need to look at what is happening outside the cases, at the way in which journalists are attacked and pro-government by top government officials. And on the one hand, in a country with a functioning system of the rule of law, as bad as these kind of smear campaigns are, we could at least hope that courts can be independent enough to uphold the law. But we see that, and this report shows that they aren't. That these kind of, whatever the message is that is being propagated by the government in these kind of smear campaigns against journalists is flowing into these cases. Journalists are being smeared as terrorists, and evidence, and their journalism is then being used in the trial against them as evidence of terrorism. And in general, we see that that public officials, anything which criticizes them, whether or not it's legitimate criticism under international principles or not, is immediately classified as some kind of as terrorism, or, as you said, violations of different intelligence laws, of security laws. We had, I think you mentioned this case of Cumhuriyet journalists now being accused of terrorism for investigating a land lease by Fahrettin Altun, the presidential spokesman, which is again just an example of which high public officials can take criticism against them and find a way to throw these kind of terror accusations which aren't just smear campaigns but actually become court cases. And again, which just shows the extent to which the judiciary is being steered, and it doesn't necessarily mean that someone is whispering in the ear of a judge to rule in one way or the other. I don't know if that's exactly how that's happening, but we can see that the way in which the rhetoric is being used influences the outcome of these trials and across the board. And see in other cases, actually, even when journalists are released, we can still see that there are other considerations at play. Just to give an example of when IPI and a number of organizations and the journalist is represented by MLSA, Idris Saylan at the Strasbourg court, when we began to bring these arguments in favor of why this case should be heard without having completed the entire without going through the justice system up to the Constitutional Court, bringing arguments as to why the European Court of Human Rights should hear a lot more cases from Turkey, even though they haven't gone through the whole system. All of a sudden, he was released. And again, I think this is another example of, you can see this isn't, the justice system isn't functioning according to rule of law, isn't functioning according to basic notions of justice. It's, as I said, being steered by external considerations, which in some cases may be the judge's understanding that they are meant to rule in a certain way, or that, for example, whether judges are promoted or not, whether they are removed from the case or not. All of this depends on the way in which they rule, and this is really, as I said, this is what arbitrary justice looks like, as opposed to a system of the rule of law. And this is what the report really, for me, it is at the heart of the report and at the heart of the work that I think all of our organizations are doing, trying to monitor and report on these cases.
Thank you. And you're right. The report clearly shows that judiciary is being instrumentalized for this means. And Elif is, I think, not with us due to internet problems, but I hope she'll be back. So yes, this is true, but we also see this not just with smear campaigns, but also there are many journalists who have recently been claiming that these kinds of lawsuits have become incredibly unforeseeable, and this arbitrariness also puts a great pressure on journalists, and who clearly even say themselves is that they're prone to self-censorship now, or they refrain from looking at certain news stories. They refrain from investigating certain stories because they don't know which public official will be filing a lawsuit against them. And you're right, maybe someone is not whispering anything to a judge's ear, but this definitely affects the process. One thing I want to say before we end this session is also that it's for me, like the big part that we do as IPI and MLSA together is actually composing of that report, because MLSA, yes, organizes the trial monitoring process logistically here in Turkey, but then one of the biggest parts of compiling this report is analyzing the data, compiling the data, analyzing the data, categorizing it, and trying to make sense of it. And that is a very important work. And this is important work for civil society across Turkey, not just for journalist cases, but in many different categories as well. Women's organizations, LGBTI organizations, labor organizations, they all do these kinds of monitoring efforts in order to fight impunity and create solidarity and also advocacy for their own causes. So trial monitoring is definitely has become a very, very crucial tool in Turkish civil society, unfortunately. But it's also something that we see that gives results, like you said, Scott. And in that sense, like for me personally, the creation of this archive, the creation of this data is very, very valuable. And what makes our job, what the hardest part of our job is probably making sense of this data and presenting it to the public in a meaningful way that makes sense. And this is valuable because this archive will hopefully will help in the future as well, when these judges or these prosecutors who, as we've seen in the failed coup attempt and the many purges that followed it, who give these judgments that now might be also taken off duty at some point or might be tried in the future. And the data that we keep will hopefully be used maybe one day as evidence in showing that they were indeed not independent. And Elif, maybe before we end, let me give the floor to you for one last time to talk about why it's important for us to be in the courtrooms and how trial monitoring can, how should I put it, strengthen civil society in Turkey.
Well, actually, you have, as you have mentioned at the beginning of the panel, we should say that our presence in the courtroom actually creates a good sense of solidarity. I mean, especially when it comes to the Kurdish journalist trials, we saw that most of the time no one is observing or no one is even covering the trial. So these people are feeling very lonely that way, and no one cares. Because if Can Dündar is on trial, everyone is covering it, everyone is observing, everyone is there to show their solidarity or their, how can I say, themselves. But when it comes to the Kurdish journalists, mostly Kurdish journalists, yeah, that's the situation. Therefore, it's very important for us to be that. Actually, also, the other one is important to, as I have mentioned before, because of the court, because when they see us now they see us actually. They ask us who are we? They ask us why are we doing, where are we doing this for example. So it's really it makes our work very visible. So when we are contacting with the lawyers or with the family or with the journalist herself, it really helps putting our case or making dialogue or receiving documents in some ways. Well, the other part, when you say that the civil society, how it's going to strengthen the bond, actually, as I believe that we are the only one who is observing, like the freedom of speech trials are the only ones which has been observed by very systematically. Otherwise, there's only one project, Faili Belli, which is for human rights violations. It's the Havlamerk is I don't know the English word name of it. Their project, and it really needs to be observed when it comes to the femicides. Now it's actually the very highlighted topic, very strong topic in Turkey. It's very important to observe femicide trials, for example, because there are a lot. I have been also covering some of them, and it's very easy to how the right to free trial actually helps to create the justice at the end of the hearing, to, how can I say, enlighten the incident and showing the truth itself. So it's a lack of monitoring in Turkey when it comes to femicides or the hate speech trials, but I believe that it's going to be an example that we have in the, because as I've said at the very beginning of my word, we were the first ones who started trialing, monitoring these trials systematically and in a project in Turkey. And it's really make an example for a lot of civil society organizations as well, and they followed our lead. So good work.
So thank you, Scott and Elif, for being with us today. And our free expression trial monitoring report, the final one, can be found on both MLSA's and IPI's websites. And we invite anyone who's interested in the topic to give it a look. It's, I'm sure it will give great insights to anyone who's interested. And thank you.
Thanks a lot. Thank you, Ajay.
Thanks.